Bismillah ar-Rahman ar-Rahim. My name is Khurram Baig. I'm the owner of the Baig firm, and in partnership with ICNA Relief, we have been going around the city speaking at various masajid, and tonight is our honor to be here with you all at GIC. So alhamdulillah, thank you all so much. Thank you to the GIC leadership for hosting this event, and again, thank you to our partners at ICNA Relief for helping organize all of this. I'm just going to do a very brief introduction, and then I'm going to turn the microphone over to Brother Bukhari Nuruddin, seated to my right. So you all are here because you know tonight is a workshop or seminar presentation on wills, trusts, and estates. So Brother Bukhari is obviously going to go into tremendous detail explaining several of the key legal concepts and answering your questions. But I'm just going to give you a brief explanation on who we are as the Baig firm, and then kind of again what we think tonight is going to be like for you all. So the first thing I want everyone to know is that the Baig firm has been around since 2012. Alhamdulillah, it has been focused on the Muslim community. It has been a law firm owned by Muslims with Muslim employees, doing work on behalf of Muslim clientele. Not just the type of work that we hear about when it comes to, you know, constitutional law and civil rights. Okay. I can. Okay, so Bismillah, let me try again. Is this better? Okay, I'll just try to talk very loudly. Okay. Assalamu Alaikum. Let's start over. Thank you very much, brother. Hopefully everyone can hear us. If you have a hard time hearing us, please just let us know like the brother did. Very briefly, the Baig firm. We are a Muslim-owned law firm. We have Muslim employees, and our goal from the day we were started was to be a resource for the Muslim community. Alhamdulillah, over the last 12 years, we have done that. Unlike many organizations that you are aware of that have their specialties in, say, constitutional law or specialized law, we are more of a general business-based law firm. So the majority of our clients, are involved in business in some way, but that's not the only type of clients. We like to think of ourselves as a type of law firm where every person can come and can get help in whatever they need. Our emphasis is on business, yes, but we also have expertise in family law, in criminal law, in injury law, and as of this year, within wills, trusts, and estates. And that's a very important point. And the reason I want to mention that is because, like many of you in the room, and I see a lot of familiar faces. I know there's people who have been in Atlanta, the Atlanta area for a long time. My family's been here since '79. I remember a time when, first of all, masajid like this were not everywhere. You had to go down to 14th Street, okay? I remember that time. I also remember a time when there were no Muslim lawyers in town. I remember a time when there was nobody in our communities that could talk to our people about wills and trusts and estates, and especially from an Islamic perspective. I remember that time. And it was a goal for me personally, growing up in this community, starting a law firm in this community, that, hey, we should be the law firm that does that. We should be that law firm because we've been here the longest. This is our community. We should be that resource. So alhamdulillah, I'm very, very happy to say that at the beginning of this year, we were able to come together with Brother Bukhari Nuruddin. He joined our firm, and he is the head of our wills, trusts, and estates practice. And that has given us tremendous access to be able to provide services that have been very needed in our community. So without further ado, what I want to do now is turn it over to Brother Bukhari. This is how the night's going to go. Brother Bukhari is going to go through a prepared presentation, and he's going to give you an overview on the wills, trusts, and estates area of the law. Tonight is not meant to be a very specific answering every detail type of question session. That's not what this is. This is general information, very high level information. The goal is that when you leave here tonight, inshallah, you'll have a very good understanding on what is a will, what is a trust, what does the estate mean, how does the legal process work in Georgia. You'll have a good understanding on that. You'll also have an opportunity to ask questions. That's going to happen at the end. So inshallah, we're going to just follow that format. The one thing that we would request is if you have a very specific situation with a very specific question that's unique to just you, talk to us offline about that. We'll talk to you about our consultation process and how you can schedule with us to to deal with your individual issue. But tonight, inshallah, we want to share with you general information, make sure everyone here feels educated after tonight. That's our goal, inshallah. So with that being said, I'm going to turn it over to Brother Bukhari Nuruddin.
Jazakallah khairan. Can you all hear me okay? I don't project as well as Brother Quorum. I can use the mic. Can y'all hear me okay? Everybody can hear me okay?
A lot of blank stares.
A lot of blank stares. Can you hear me? I'm gonna use the mic then. Okay.
You got something, Brother Abdul?
This one goes to the. Can you all hear me better now? Better? أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم إن الحمد لله نحمده ونستعينه ونستغفره ونعوذ بالله من شرور أنفسنا ومن سيئات أعمالنا من يهده الله فلا مضل له ومن يضلله فلا هادي له وأشهد أن لا إله إلا الله وحده لا شريك له وأشهد أن محمدا عبده ورسوله. All thanks and praise is due to Allah. We seek His help and His forgiveness. We seek refuge in Allah from the evil within ourselves and the consequences of our evil deeds. Whomsoever Allah guides will never be led astray, and whomsoever Allah leads astray will never find guidance. I bear witness that there is no God except Allah, alone without any partner, and I bear witness that Muhammad sallallahu alaihi wasallam is His servant and messenger. My dear respected elders, brothers, and sisters in Islam, Assalamu Alaikum wa rahmatullahi wa barakatuh. So I want to thank Brother Quorum for that wonderful introduction. Again, my name is Bukhari Nuruddin. I am originally from Providence, Rhode Island. Interestingly, I came to Atlanta to attend Morehouse College. I finished Morehouse College in 2004. And then I went to Howard University School of Law, and I finished in 2008. I came back to Atlanta to practice, and I thought I was doing something as a young Muslim attorney. As it turns out, that trail had already been blazed by this brother right here, mashallah. So when I graduated from Howard University School of Law, I came down, and my network told me the first person that I need to get in contact with is Brother Quorum Beg. And so, interestingly, I reached out to him and we got together maybe in early 2009. And I asked him, he had been in practice for about 5 years. He's about 5 years ahead of me in terms of graduating from law school. And I asked him, I was like, well, what advice do you have for me as a young lawyer? And he said, man, just put your head down and practice, right? So just like there are these basketball hoops in this gym, right? He said, put your head down, practice. Just go at it with everything you have on a daily basis. And you know, over time, it'll come together in a way that, you know, is preordained by Allah subhanahu wa ta'ala. And so we fast forward to this point and to Brother Quorum's remarks. The Beg firm is what we call a full service law firm. It's an entity that allows for wherever you're at in your life cycle, right? We can service those legal needs. And importantly, with respect to wills, trusts, and estates, we can deal with the distribution of your assets upon your passing, right? And so, you know, the thrust of what we're going to talk about today are the details associated with that and how, as Muslims, we think about this notion of estate planning and how to most appropriately and properly deal with the distribution of your assets upon your passing. And also, and most importantly, I would say, in compliance with the Sharia, right? So I want to thank ICNA for sponsoring this event and Sawani Masjid for this opportunity to speak to you today. The Prophet Muhammad sallallahu alaihi wasallam ordered all Muslims to prepare a last will and testament. Abdullah bin Umar narrated that the Prophet sallallahu alaihi wasallam said, "It is not permissible for any Muslim who has something to will to stay for 2 nights without having his will and testament written and kept ready with him." That's from Sahih Bukhari. Islam contains rules relating to the dispositive provisions of a person's wealth that are binding upon members of the faith. The majority of these rules are outlined in verses 7 through 14 of Surah Nisa in the Holy Quran. At the Begg firm, what we typically like to do is outline for our clients who their heirs are likely to be and what their unascertained heirs are likely to receive under a distribution scheme based on their particular madhab and their values. So let's break that down a little bit. An heir is someone who you may or may not be related to, right? That is going to receive your assets, your wealth, your funds, your money, your property upon your passing, right? But an heir is not ascertained until the time that you pass away, right? So what we do is we say, all right, we're going to have a consultation with the brother. The brother has, let's say, a wife, has a son, has a daughter, right? Has parents, right? And then we put together an estate plan to crystallize what that distribution scheme looks like at the time that the will is prepared. But ultimately what may happen is you may have your parents pass away, and then their share is then recalculated and then distributed to who your actual heirs wind up being. So that's the distinction between what an unascertained heir is and what an actual heir is. An unascertained heir is just people who are likely to receive your distribution upon your passing. Who your actual heirs are the people who actually are the ones that receive that distribution upon your passing. So in order to prepare a customized plan that achieves a client's unique goals, what we try to do is understand our client's values, their convictions, and most importantly, his or her religious beliefs. So for Muslims, estate planning is not merely an expression of an individual's love for his or her family, but also an act of religious devotion and a form of worship. American Muslims enjoy an above-average median household income and roughly $100 billion in disposable income. America's nearly 6 million Muslims are projected to become the second largest religious group in the country by mid-century. Muslims who seek the services of an estate planning attorney are looking for someone to assist them in protecting their loved ones, in preserving their assets, and ensuring family harmony. Muslims are also motivated by a desire to comply with religious obligations to distribute their estate in accordance with the Islamic law of inheritance, to ensure end-of-life care decisions are made consistent with what we call Islamic bioethics, and memorialize that their funeral and burial rites are administered in accordance with Islamic law. Now, in reality, not every member of a faith tradition adheres to all the rules of that tradition all the time. And this is where I want to kind of focus the bulk of our talk with you this evening: the basics of wills, trust, and estate planning generally, how the probate process works in a nutshell, and what we're seeing in practice on a daily basis. So let's just kind of try to tackle the elephant in the room at the outset of this conversation. And that's really what we're talking about in terms of what we're seeing in practice on a daily basis, this notion of intestacy. What intestacy is when a person passes away without a will. Georgia law deems that that person is called what's called intestate, or you pass away without a will. And because we don't know the day nor the hour of our passing, what we're seeing is that many people, too many in fact, from all different ages and backgrounds, are passing away intestate or without a will. This makes the resolution of a person's final affairs very difficult for those that they leave behind. It requires court supervision during the entire process. In a lot of instances, a bond to be put up by the person that is deemed by the court to be what's called the administrator or the manager of a person's estate when they pass away intestate. If children are left behind by the decedent or the person that passes away, sometimes the courts will require what's called a guardian ad litem, or a lawyer for the children, to protect the children's interest in terms of inheritance. Sometimes conservatorship is required, which is another court appointment that requires a person to be appointed to manage the financial affairs of that minor or individual that requires conservatorship. And sometimes it imposes Georgia's intestacy laws on the distribution of a person's estate. Importantly, this is a distribution scheme which is not the same as the verses of Surah An-Nisa, and this process can tie up the ultimate distribution of an estate for years. So in our practice, what we try to do is we meet people wherever they're at in the planning process. The most important thing, if you get nothing else from this presentation today, the most important thing is at some point in time, you have to sit down and do some form of estate planning. There are several different tiers of estate planning, and we'll go through that in some detail tonight, but the most important thing is do estate planning, right? Because we do not know the hour or the day of our passing, this is critically important because you want to, if at all possible, avoid intestacy under all circumstances, right? So what we do is, folks will come in for a consultation. We will get to understand a person's values, their beliefs, their asset, their family background, things of that nature. And we'll have a good sense of the type of estate plan that a person needs based off of that conversation. So the first sort of tier, if you think about it, is called will-based estate planning, right? And this would include the preparation of a basic will that would name your beneficiaries, your executor or the manager of your estate or personal representative, and a guardian if you have minor children in the event that you pass away, right? We also prepare what are called ancillary documents, including a document called an advanced medical directive. This is a document that gives you an opportunity to state what you would like your healthcare treatment preferences to be upon your passing, whether you want to be buried or cremated. Typically, our Muslim clients wish to be buried in accordance with the Sharia. And we also like to put together a document called the financial power of attorney for our clients. This gives you the opportunity to name someone to manage your financial affairs in case you are incapacitated or you're traveling and there are financial matters that need to be attended to, that you cannot do so in that immediate moment. So we find that these are sort of the foundational documents for a will-based plan. And we typically recommend this plan for everyone, right? And it'll be in different tiers of what we do overall generally in estate planning. But we typically recommend this type of plan for our younger clients who are just starting out in their careers, just establishing their family, maybe have minor children that they want to have guardians appointed for in case of their untimely passing. We also can do pre and post-nuptial agreements, and so we do that as part of the consultation process for the will-based plan. Now, importantly, there's a second tier of estate planning that is called trust-based planning. And the difference between a will and a trust is that just like we talked about this notion of intestacy, right? You have to go through the probate courts in order to distribute your estate from one person to another, from one generation to another, to your heirs. In a will-based plan, similarly, you still have to go through the probate courts in order to distribute your assets to your heirs, right? It still requires court supervision. With a will-based plan, it's less intrusive, right? Courts will generally give you broad leeway because there's a will that states what you want your preferences to be in terms of the distribution of your estate. And so courts just want to see that that's in place, and they'll basically rubber stamp it. They'll basically sign off on it and give your executor broad leeway and discretion to handle those affairs as they see fit. Now, with a trust, what a trust is essentially a separate legal entity that you create that handles the distribution of your estate in a completely private manner, right? Because we do a lot of the planning on the front end of this. What typically happens is we prepare the trust. The trust will outline what you want the distribution of your estate to be, both during your lifetime, but also after your passing. We combine that with a document that's called a pour-over will, which essentially is a document that essentially points to your trust and says, I have a will in place. Any property that is not already in my trust at the time of my passing, by operation of my passing, I want all of that property to go into my trust, and that happens automatically by operation of law, right? This is a completely private process when we talk about trust-based planning. Now, we also include ancillary documents in the trust-based plan as well, and it's a much more thorough and much more comprehensive form of estate planning, but each planning session that we do starts with a consultation, and then based off of the results, the feedback that we get, where we're starting with the foundational information about you, your values, your beliefs, your family structure, your assets, will point us in which direction that we need to go. So it's not a one-size-fits-all kind of thing, and this is why we, recommend that you steer clear of template-based planning, or just finding a document online that you kind of do on your own. There are significant details that are associated with the process of trying to distribute your estate in compliance with all of the different factors that we've already outlined. And you want to make sure that that process is done both in compliance with the Sharia, to the extent that that is your goal, but also in compliance with Georgia law, and to make sure that it's done in the most tax advantageous way that you possibly can. And so when we talk about taxes and estates, you're talking about, there are essentially three different buckets of taxation, right? So the first bucket of taxation is called the gift tax. So this is the example that we typically give when we do these presentations. Quorum is my best friend, right? In honor of that friendship, let's say, in the year 2024, I want to gift Quorum some money. So I can gift him up to $18,000 per year, tax-free. There's no tax to me, there's no tax to him. The moment that I gift him $18,001, right? That $1 over starts to eat away at what we call your estate tax exemption. Every individual has a lifetime estate tax exemption that is applicable to their estate upon their passing. Under current U.S. tax law, the lifetime estate tax exemption per individual is $13.6 million. Why is this important, right? Most of us will never see that kind of money in our lifetime. I know I won't, right? The reason why this is important is because, let's say, there may be a handful of individuals in this room that may meet that threshold, right? If you do not engage in proper planning, right, any money that is included in your estate, the value of your estate at the time of your passing, anything above that $13.6 million threshold is taxed by Uncle Sam, by the federal government, at 40%, right? And so you want to try to plan the distribution of your affairs in a way that minimizes your overall estate tax liability, and to the extent that it's underneath that $13.6 million threshold, alhamdulillah. To the extent that it is above and beyond that, that's part of the reason why we encourage folks to come in and meet with us, have a consultation to figure out ways to bring their estate tax within that threshold so that they can distribute their affairs in a way that is most tax advantageous. And so essentially everybody's situation is a little bit different. And so what we do is, when we're doing the planning, there's no one size fits all solution. So the estate planning process requires us to get to know you, your family history, your assets, your values, in order for us to prepare a customized plan, which is the most important thing, that fits your particular situation. It's our goal to be a trusted advisor to you all, and that you'll come back to us when your life circumstances change. Typically every 3 to 5 years is a good rule of thumb to kind of check in and update us as to things that are going on in your life, to potentially conduct additional planning as necessary and appropriate, and to handle the resolution of your final affairs upon your passing in keeping with your values, your beliefs, and your wishes. So with that, those are my prepared remarks. I will go ahead, I'll open the floor up to questions.
Maybe from the sister side, any questions?
Yeah. Yeah. So the sister's question is a good one and a very important one, and it centers around this notion that a non-Muslim cannot inherit from a Muslim, and a Muslim cannot inherit from a non-Muslim. So the sister's question was, what options does a person have regarding estate planning when they have family members who may not be Muslim? how can they take care of them, as heirs or distribute, to them from their estate. So, when we talk about Sharia compliant estate planning, right? Think of it as like a 1/3, 2/3 split. So the 1/3, right? Scholars have named that, right, the wasiya, right? This is what we call the discretionary bequest. You can give this money to any charity, any individual, any entity it is that you want to give it to, up to 1/3 of your total estate. The 2/3 that's remaining, right, 100% under Sharia, right, in accordance with the verses of Surah Nisa, has to be given to your Islamic heirs, right? And so there is no sort of, way to get around that. And so when you're thinking about planning for family members that you may have that are not Muslim, right, there are a couple of different ways to kind of go about that thought process. One is potentially to gift property to them during your lifetime. That tends to be the most effective way to go about doing that, right? Because there are some schools of thought that say that, even with your discretionary, right, your wasiya, that those funds should not necessarily go to non-Muslims, right? And so, sometimes clients will opt to gift property to their non-Muslim family members during their lifetime, as a means of trying to sort of take care of them out of their estate prior to their passing. Sometimes, our clients will say, I'm going to give to, particular individuals out of my 1/3 wasiya, and then everything else will go to my Muslim family in accordance with the Sharia and the calculation of shares. Yes, brother.
Question regarding Medicaid and Medicare.
Yes, sir.
What we heard is individuals who have or use the services, they pass away, their houses, will be used to pay back for those services. Is that true?
That's one of those questions that's sort of beyond the scope of this conversation. What I would encourage you to do is, we can follow up on that. That's something that, is very particular about, a person's how they're receiving those types of benefits. And like I was telling the brother earlier, right, there are certain types of estate planning techniques that can be used to ensure that result does not happen. So we can follow up on that, but that's beyond the scope of the conversation.
I think he had a question right behind him.
Yes, brother. Wait, this brother right here. Hold on.
Him and then, yeah.
Yeah. So the question was, how does an investment property work from a liability standpoint within the context of estate planning? So it's similar to what I was telling the brother earlier, right? Anytime you go about establishing a business, so let's say you have an investment property, that property is typically owned by an LLC, at least I would hope that it is, right? That LLC then would be owned by the trust, right? So the LLC owns the property, the trust owns the LLC, and you're a beneficiary of the trust, right? So that's typically conceptually how we like to set things up. And like I told the brother earlier, that gives us, several layers of insulation, from claims of creditors or, any legal issues that may come up as a result of that. Like if you are renting it out as an Airbnb and somebody slips and falls on your property, things like that tend to be, from a liability perspective, limited to just, an insurance proceed or the assets of the one business itself, not your overall estate. Potentially. I mean, if you have like major life changes, the question was, does the estate plan need to be reviewed periodically? And like I mentioned before, typically we encourage our clients to meet with us maybe every 3 to 5 years or so. Sometimes younger families have major life changes that they'll go through. So you want to maybe add a beneficiary. You maybe want to transfer, additional property into your trust. What we try to do is, if we're doing trust-based planning, we try to plan it in such a way that, when we're doing the planning for you, there's one major trust funding event that takes place. And then, like I said earlier, as part of the planning process, we include what's called a pour-over will. The pour-over will, essentially points to your trust and says, at my passing, anything that is not included in my trust at the time of my passing, by operation of my death, is transferred over into the trust. So there may be some follow-up work associated with that, but it really just kind of depends on a particular individual's facts and circumstances.
We're going to check with the sister side real quick. Any questions on the sister side? You have a question? The question is, what about jewelry and tangible things like that?
Yeah. So so that would fall under the category of what we call personal property, right? Now, some people, like the sister asked, can I give property away, right, during my lifetime? If there's like a sizable, if you have a lot of jewelry, right, there are a couple of different ways to think about this. You could like do a valuation of all that jewelry, right? So you have like a dollar figure associated with it. You could say, all right, I want to, while I'm still alive, give that property away. Otherwise, right, if you have a will-based plan or a trust-based plan, that jewelry would be deemed to be personal property, right? That would, essentially need to be, if we're talking about Sharia compliant planning, would need to be liquidated or sold off, right, to arrive at that dollar figure to be then distributed to your heirs in accordance with the Sharia, right? So two different, ways to think about it, two different schools of thought. But what I would encourage you to do would be probably to gift it during your lifetime, if that's something that, is on your mind or on your heart. So, yes, brother.
Let me. This brother was waiting,
Yeah.
and then you next, please.
Yeah, so the question was, as a beneficiary, do beneficiaries pay taxes on gifts, on trust, things of that nature? So, essentially, when we're thinking about taxation, like remember the example that I gave about, quorum, right? There's a gift tax threshold and then there's an estate tax threshold. So when we're talking about taxation of a person's estate, there are a few different things that you want to think about. So the first is, right, like April 15th every year, like clockwork, we all have to file our taxes, right, typically, right? When you pass away, the year after your passing, you're still going to have to file a final income tax return, right? Anything beyond that, like any income that's received to the estate, if you have business interests, things like that, right? Those would start to be subject to estate tax returns. From a beneficiary standpoint, right, you're receiving your inheritance, and your inheritance is deemed to be a windfall. Depending on the amount of inheritance that you receive, you may or may not be subject to taxes. It would depend on what it is that you're receiving. The idea is that the person that's passing away is they're giving you something, right? So that inheritance you're receiving, now, there are complex situations where, you may receive like some property. Let's say your parents purchased a property when, we were at the, the valley of the recession, and they purchased a house for $16,000. Now it's worth $700,000. So we're talking about like, the concept of basis and the step up in basis. So, the details associated with whether or not a person, a beneficiary actually pays tax on the inheritance that receive is a little bit beyond the scope of the conversation, but these are some of the things that you want to think about from all right, this is what I stand to receive. What tax liability potentially would I be subject to in the event that I receive this one particular, asset or that one particular asset? For our Muslim clients, typically it doesn't work like that, because typically we're talking about distributive shares, right? So, a father receives a sixth, or, a mother receives an eighth, things like that, right? So a lot of times we're talking about, liquidation events, or we're planning for customized solutions for clients that may not fit neatly within, Sharia compliance, but may be a preferred method of planning for a person to meet their particular estate planning goals. So we don't make value judgments on whether a person does a Sharia compliant plan versus a plan that may be more or less tax advantageous. We give you the options. We say you pick and choose what you want to do.
So, gentleman here.
Mm-hmm. Mm-hmm. Correct. All of your property would be subject to the probate process. Yeah, but no, not necessarily. And the reason why is because a person passes away, they have an interest in an LLC. That interest is their property. That interest is their asset. Operating agreement? Mm-hmm. Yeah, potentially. I mean, so the question deals with whether a person's ownership interest in, like, let's say an LLC, right, would be subject to the probate process if there's not like a trust-based plan set up, right? And in my view, right, I think that a person's ownership interest in an LLC, like let's say you and this brother all own 1/3 of an LLC, right? Now, let's say you pass away, right? You, like, that interest is still held, right? But it would have to be probated in order to be an executor appointed, right, to manage the essentially sell off or the buyout of your ownership stake in that LLC to then be distributed to your heirs. So when we're talking about trust-based planning, we're trying to, cut all of that off at the pass and kind of do all of that sort of planning and transfer of business interests into the trust entity, right, at the outset of the trust. That's what we call the trust funding process. That way, upon your passing, none of it has to be appointed by a judge. There's no executor required or anything like that. If there's an ownership interest that's owned by the trust, right, the trust can then separately, whoever your successor trustee is, can then separately negotiate for whatever leveraged buyout or whatever buyout needs to happen at the time of your passing, based off of the interest that you had in the business at, during your lifetime. Yeah. Correct. So this is an interesting question. The brother's question was, does a trust that's set up in the United States have any legal value in foreign countries? So, this gets into, it's a little bit beyond the scope of this particular conversation. What we typically like to do in scenarios where we have clients that have assets that are not based in the United States is we will set up their domestic trust, right? We will contemplate setting up or doing trust planning in locations where there may be legal flexibility, right, to be able to house property in your trust in a foreign jurisdiction. to the extent that there are, treaties or legal agreements between the United States and whatever particular country, we want to think about that. But most importantly, what we want to do is make sure that we have, essentially sourced local counsel in, let's say, Pakistan or wherever, right, to make sure that we are transferring that property into the trust in the most legally compliant way possible, right? We want to make sure that the transaction is recognized both by the authorities in whatever country it is that, the property is located, and the United States as well.
Thank you.
Alhamdulillah. Brother, there's one more question.
So the next question is the savings as 401k
Yes.
and IRA.
Yes.
They have legal protection.
So,
They don't have to be part of the trust or maybe.
yeah. So,
One question. Second thing is, can you comment about the Roth IRA conversion? I don't know if you're dealing with that.
Roth IRA conversions. That's more so a question that would be applicable to a financial planner. Roth IRA conversions typically, kind of follow you from, job to job. So, you may have had a job that, had an IRA trying to convert over that amount to a new IRA that you're setting up. So that's a question that would be more particularly targeted towards a financial planner. With respect to the brother's question about retirement accounts, sometimes bank accounts, things of that nature, you're talking about this idea of what we call beneficiary designations, right? So when you go to set up your 401k, right, your employer will give you the opportunity to say, I want such and such individual to be the beneficiary of this 401k. The legal effect of that is that is property that's deemed to pass outside of your estate. So it's not like probate is not required in order for the person to receive those funds, right? Now, what we like to do is, if we're talking about trust-based planning, you would then follow up with your employer. You would say, I've set up this trust. I want the trust to be the beneficiary of the 401k, right? And then that way, everything is flowing into one bucket, right? When we think about Sharia compliant planning, you never want to have a little bit here and a little bit there, a little bit go to this person, a little bit go to that person. You want to plan comprehensively based off of who your Islamic heirs are likely to be. And so what we do is we say, all right, we're planning for this. We want to put everything in one bucket and then have the bucket siphon off to the particular beneficiaries in the distributive shares that are appropriate under Islamic law. The sister left.
So, Sister Fatima, did you have a question?
Oh. Sorry. Fee. Yeah.
Maybe before we address the fee question, field his question, you might be able to work that in.
Yeah.
I'll just tell you the relationship between ICNA and our firm is just a partnership. So ICNA is obviously what ICNA is. They're a community organization. We're a private firm. They wanted to bring this service to the community, and we partnered with them. They organize it, and then we provide the information. So that's the relationship. Yeah, but it's not a business relationship.
Yeah, we'll get there. Was there another question about?
So, painting a very common scenario, even with the 40s and 50s, most of their residents are in their residence as an equity.
Sure.
And they can work on it. They would have the house, and again, circumstances and evidence and what they see around them. Usually the home would be owned jointly with the right of survivorship.
Sure.
And then left back by life insurance, where wife is the sole beneficiary, is the husband passes away, so she can take the money, pay off the mortgage, and she has the whole house. Why? Because sometimes people are afraid, they don't want to give the wife to the views and fancies of their spouses, their kids and their spouse. Their bank account would be, again, held in the same fashion, jointly with the right of survivorship. 401k, as you mentioned, you can designate beneficiary. and the bank account, how would a will or a trust help in that regard? And part two of that would be, let's say I did that, I'm in violation of the Quranic injunction that you need to distribute your belongings, or your belongings need to be distributed after you pass away this way, right? And again, some people say, oh, just giving 1/8 to your wife, 2.5%, how should you survive? So how does the will or trust?
It seems,
Some organizations are 50, I know.
yeah. No, and I think, okay, okay, and then I'll let you know about the fees. Yeah, so essentially what the brother's asking about is there are certain ways that, you know, couples, families' financial affairs have been set up for a long period of time as it pertains to property rights, how property is titled, how, you know, various assets are titled, and, you know, how does one think about this notion of, well, this is what I have, how do we arrive at what it is that we're discussing, which is Sharia compliant planning? And the brother actually answered his own question, right, in that, you know, when we're thinking about this notion of joint tenancy with right of survivorship, by operation of law, the whole interest, your whole 50% interest in that property would transfer to your spouse upon your passing. That, by definition, is not compliant with the Sharia, right? Because your 50% interest, remember, 1/3 of it is governed by the wasiya, 2/3 of it is governed by the fara'id, right? The required legal distributive share to your heirs. Your heirs may be your wife, but your heirs may also be your children or your parents. And so what we try to do is, when we talk about trust-based planning in particular, we don't do asset transfers necessarily when we're talking about will-based planning, because that's beyond the scope of what a will-based plan would entail. All of that would be subject to the probate process. You know, but when we talk about trust-based planning, we're talking about retitling that property, right? Typically as still a joint tenancy with right of survivorship, but a joint tenancy with right of survivorship between your revocable trust that's been set up and also a revocable trust for your spouse that's been set up. That way, by operation of either of your passing, neither one of you own it. It's owned by that particular person's trust, and that particular person's interest in that, or I should say, that particular trust's interest in the property is then subject to the distributive rules and regulations of that person's trust, right? So it may require, by definition, property to be sold off. It just kind of depends on a person's particular facts and circumstances. Sometimes, you know, we will think about you know, various different types of trust planning. So not just a revocable trust, but potentially a credit shelter trust. But again, it goes back to what a person's values are. If your value is Sharia over everything, then, you know, you're gonna plan in a certain way to comply with those dispositive and distributive provisions and shares that are required by the verses of Surah An-Nisa. If your objective is, I just want something that's elegant, that's going to be simple, that, you know, my wife can be taken care of for her life, then we'll plan in that capacity. But it all depends on, you know, who you are and what your goals and your values are. So from a fee standpoint, when we're talking about, you know, going through these various thought exercises, our consultation fee is $250 per consultation. That's typically $250 for a consultation. Okay, for typically about an hour. A lot of times we'll go over an hour because I meet a lot of interesting people and we talk a lot, right? So, you know, the goal is that you get your money's worth, you know, and we'll meet you wherever you are. If you know, want to do a Zoom or a phone call, come to the office in Norcross in person, we can do that.
أشهد أن لا إله إلا الله